Article 3 of the revised penal code, where the felonies are defined as acts or omissions punishable by the laws is called a felony, and that there is intent to perpetrate the act from the accused.
Is it present in the definition given in the
Yes, Your Excellency. Because the Anti-Terrorism Act actually defines the act of terrorism, which is they are making it as punishable by law. And then there is also the element of intent and as well as motive on the part of the accused to be punished by the anti-terrorism.
So what is your argument, or how do you talk to the applicants and that it is basically not distinguishable, or it's indistinguishable from other crimes in the revised penal code? Like, for example, applicant said assassination or murder, and I would add sedition.
Assassination or murder or the other crimes that the applicant's concern is already encompassed in existing penal laws is that the intent for that crime to be perpetrated is different from terrorism. Terrorism encompasses a bigger sphere of intent from the accused.
Okay, last question, Agent. So, applicant also contends that the present system or the present laws punishable by the revised penal code, other special laws, is enough to curb the violence. Or what's your position on that? Why is it the Anti-Terrorism Act?
Your Excellency, the respondent contends that it is not enough because terrorism entails a greater perversity on the accused or the perpetrators of terrorism, and the respondent believes that the existing acts are not sufficient to punish these perpetrators or these terrorists and terrorist groups.
Is that in page 3 of applicant's memorial? It provided the definition of terrorism. It says there that it is only required for a person to be indicted for terrorism that his motive is to advance, propagate, promote fear or fear. So it is clear in the law that it is not intention to sow fear. So what's happening here, Agent, is that we are penalizing a person on the basis of his motive and not intent. So we're just disregarding the element of intent, which makes the crime easier to prove, because we're just saying that so long as your motive is so clear, you can already be indicted under this law. So how can we say that such law is constitutional when we are disregarding the most important element of a crime, which is the intention?
Thank you for your concern, Your Excellency. But we have to take note that the Anti-Terrorism Act is actually the terrorism that we wish to penalize in the Anti-Terrorism Act not only constitutes a mala in se, as the applicant wishes to contend, but the enactment of the Anti-Terrorism Act is actually to be classified as a mala prohibita, where the intent or the wrongful intent is not really necessary, but mala prohibita is that the intent to perpetrate the act. The intent to perpetrate the act of terrorism is the one being punished already here in the Anti-Terrorism Act.
Can you tell me again why the law is not vague?
It is not vague because, first of all, the definitions are operative and legal. There are Section B, which defines terrorism, and Section 17, which defines terrorist groups, are actually in consonance with each other. That if you look at Section 17, it has the same wording actually with Section 3. And the laws should be the law.
Yes, Agent, it is clear as to that part that there are enumerated acts by which it could constitute terrorism. But sowing fear, for widespread, extraordinary fear, anxiety, and panic, how could you say those words are not vague?
Your Excellency, thank you for your concern, but these words are not vague because there are actually sufficient standards that have been laid down in these definitions, and furthermore in the
Tell me be the standards that has been laid down that would tell me when an act is already causing extraordinary fear, anxiety, and panic?
Let's go back, Your Excellency, to the definition that I previously mentioned, that the victims, it's to incite fear and terror, and you are using the victims as to influence the main targets, or mainly the government, for example, to give in to certain demands. And for the respondent, that is sufficient standard already to prove that you're inciting fear or extraordinary anxiety or panic.
Agent, are you aware of People versus Nazar?
No, Your Excellency. May I continue, Your Excellency? Thank you. So as I mentioned, Section 70 expounds the coverage of the Terrorist Act, the Anti-Terrorism Act, to cover associations, organizations, or group of persons that have the same objectives and uses the same means in achieving them. Section 17 and Section 3, if you compare it side by side, they actually have the same wording. Section 17 should be construed with the same spirit and essence as Section 3. Laws should be interpreted in their entirety, and they should be interpreted as to avoid conflict.
How about Estrada versus Aguinaldo?
Yes, Your Honor.
What's the standard used in that test, in that case, and can you apply those standards in this specific case?
In the Estrada versus Sandigan Bayan case, what was primarily discussed was the void for vagueness doctrine. The void for vagueness doctrine mentions that for a statute to be upheld, should be only a reasonable degree of certainty, not absolute precision or mathematical exactitude. Flexibility and not absolute specificity is needed for as long as the means and bounds of the statute are validly delineated.
So, can you apply those standards for this?
It has been held in several jurisprudence that the void for vagueness doctrine is primarily, it's the judicial opinion that the void for vagueness doctrine should only be used for speech cases. Notwithstanding that fact, that legal opinion, the respondent contends that the void for vagueness doctrine is a general principle under our laws and it's found in existing laws, that it could be in support of the respondent's argument that the definitions of terrorism and terrorist groups in the Act are operative, legal, and legal.
Are you prepared to answer applicant's contention regarding the fact that EPA is a violation of their constitutional right to against a bit of behavior, meaning that it's a legislative enactment of the bill?
Your Excellency, I think it would shed light on that, but it will be expounded by the Second Council. A bill of attainder is defined to be a legislative act that punishes a crime without due process of law.